Two closely watched U.S. Supreme Court cases are around the corner, with high stakes for advocates and opponents of same-sex marriage. A look at how San Francisco sparked the debate when then-Mayor Gavin Newsom granted marriage licenses to gay and lesbian couples in 2004.
This country has always fought for the rights of minorities, whether we like it or not.
The legal counsel for ProtectMarriage.com gives an update from Washington, D.C. on preparations for the upcoming hearings.
I think they'll be mindful of their role, their limited role as judges, to interpret existing law, not to make new law.
Plus, legal analysis on how these issues might be viewed by the highest court in the land. Stay tuned for our special coverage of gay marriage before the U.S. Supreme Court. Good evening, I'm Scott Schaefer. Welcome to This Week in Northern California. Well, next Tuesday, more than 4 years after California voters approved Proposition 8, the state's ban on same-sex marriage gets a full hearing before the U.S. Supreme Court. The High Court will also hear oral arguments for and against the Defense of Marriage Act, known as DOMA. Tonight, we focus on the legal battles over same-sex marriage and the issues before the U.S. Supreme Court. It's the final stop on a long and winding legal road. So let's begin with a look at how it all started. The week of Valentine's Day 2004, newly elected San Francisco Mayor Gavin Newsom boldly, some said recklessly, ordered city officials to grant marriage licenses to same-sex couples. It was in defiance of state law, defining marriage as a union of one man and one woman.
We have reignited a fundamental debate. That's about discrimination.
Outside City Hall, gays and lesbians lined up around the block. Over the next 4 weeks, about 4,000 couples tied the knot. But it was not to last. At the urging of Governor Arnold Schwarzenegger, the California Supreme Court stopped the marriages and later voided the unions. Over the next 4 years, the issue snaked its way through the state judicial system. In 2008, the California Supreme Court ruled that banning gay unions violated the state constitution, saying marriage cannot be denied based on sexual orientation. Newsom declared victory.
As California goes, so goes the rest of the nation. It's inevitable. This door's wide open now. It's gonna happen, whether you like it or not.
The ruling triggered a wave of joyful weddings, this time across the state, including the celebrated union of two longtime lesbian activists, together since the 1950s. But the ruling infuriated proponents of traditional marriage, who soon collected more than 1 million signatures for a ballot measure, Proposition 8, to amend the California Constitution and restore marriage to opposite-sex couples only. On the same night Californians voted overwhelmingly to elect Barack Obama president, they narrowly passed Prop 8 with 52% of the vote. Once again, gay marriage was illegal.
The people are the supreme power in California. They created the judiciary, they created the legislature, and they control the Constitution. And they have decided that marriage should be between a man and a woman.
Supporters of gay marriage asked the California Supreme Court to strike down the newly enacted Prop 8, but in 2009, the state's High Court upheld it. That ruling was the end of the road in state court, but marked the beginning of new avenues in federal court. In 2010, federal judge Vaughn Walker struck down Prop 8, saying it violated the U.S. Constitution's guarantee of equal protection under the law. Then, in a split decision, a 3-judge panel of the Ninth Circuit Court of Appeals upheld that ruling last February, setting the stage for a final legal battle before the U.S. Supreme Court. This past Valentine's Day, gay couples demanded marriage licenses at San Francisco City Hall, as they have every year since 2004. They were again turned away.
It affects us in so many ways in our everyday life, and what we just want is to be treated fairly.
I spoke with Lieutenant Governor Gavin Newsom recently about what compelled him to take a leading role in the gay marriage debate 9 years ago. Lieutenant Governor Newsom, good to have you with us.
Great to be here. Thanks for having me.
Take us back. It's almost 9 years to the day,
Yeah.
2004. These marriage licenses began to be issued in San Francisco. You had just gotten into office. What got into you? What were you thinking?
I went to the State of the Union. Nancy Pelosi made a terrible mistake by giving me her husband Paul's ticket to watch the State of the Union by George Bush. And I sat there slightly bewildered up in the audience, listening to the issues of the day: abstinence, drug testing, steroid abuse. It ended with the idea that indeed he was going to fulfill his private commitments, now made public, around a constitutional amendment to ban same-sex marriage. Yeah. And it occurred to me that, at that moment, that we had to respond. As mayor of San Francisco, I felt an obligation. The question was how.
Yeah. So you just decided, I think it was a Thursday or Friday, and people started lining up. And it seemed to kind of spring. It came on suddenly. No one was warned. I mean, what kind of conversations did you have with the city attorney, the attorney general?
No, it was not. This was done in a very deliberative way. We went through a very thoughtful process. Every memo we put together was done in the context of a legal case that was being made. We had folks from NCLR. We had other folks that were organized in this effort. We had private attorneys. Because I'll say respectfully, it was a little bit of friction within City Hall over the city attorney's office.
And I should just say NCLR, National Center for Lesbian Rights.
Yeah. We talked about what we can do, and we organized a very principled effort because we knew ultimately this would lead to litigation, and we wanted to put a human face on it.
There were a lot of critics, of course. Some of them, starting with the governor, Arnold Schwarzenegger, who talked about, I think, chaos in the streets of San Francisco at the time on Meet the Press, exactly. But there were some surprising critics. Barney Frank, the openly gay congressman from Massachusetts, saying it was diverting attention from the real gay rights struggle.
Yeah.
What, of all the criticism you got, what hurt the most?
Oh, the Democratic criticism and the private criticism, and the fact that a lot of my friends who said, all giving me the same advice, and truly, you ask, what's the advice you'd give as a newly elected mayor? They said, well, do what you think is right. And then when you actually do what you thought was right, all of a sudden they say, wait a second, hold on now. You need to ask for permission, and there's a process here. And that was ultimately the protocol issue with Frank and others, is they expected permission, that somehow, who are you? You're new to the scene. We've been at this for decades, and they have been.
And you're
legends.
Straight.
And I'm straight. And that's an issue. That was an issue, too. It's like, who gives this guy the right to be that advocate?
For us and set our agenda.
And the interesting thing, a lot of the members of the gay community, particularly the larger national organizations, they weren't ready for this fight. They weren't even thinking about this fight. I mean, remember, in 2004, we were barely entering into the debate around civil unions, having gone through that half decade around domestic partnerships. Gay marriage was never on the radar screen during the mayoral debates and the issues around who's the next mayor of San Francisco. So it was a tough issue for a lot of folks.
You mentioned President Bush, George W. Bush, in his reelection. He, of course, won in 2004, and it came down to Ohio, which had a gay marriage ban on the ballot. And the day after the election, I believe, Senator Dianne Feinstein, one of your close friends, said blamed you, in a sense, said it was too much. People weren't ready for it.
I get it. A lot of folks felt that same way. Terry McAuliffe, the head of the party, all but blamed the election on the action. So I get it. Now, with that, the dust settled, and they did, as they do with the exit polls, they analyzed those exit polls, and you saw it wasn't, there was 10 issues. Social issues was number 5, behind the issues, other issues. And interestingly, it broke both ways. Enthusiastic for Bush, enthusiastic for Kerry.
But you say the dust settled, but, fast forward 2007, 2008, Senator Barack Obama, running for president, comes to San Francisco to raise money, and word was he didn't want to be photographed.
Yeah,
was that true?
I was
Willie
Brown, myself, Kamala Harris. We're doing those 2 fundraisers for him. One downtown a restaurant, another one a Western Addition. And he had strong opinions. A lot of folks had strong opinions. And their
was
advisors,
it strong opinions, or was he worried about?
Everyone was worried. Everyone. I mean, I had that brief moment where you're, the new person and the rising star, and I was going to go to Boston during the convention and speak, and all of a sudden, McAuliffe and there's folks are saying, and I said, I get it. Yeah. And so all these folks that were surrounding me, enthusiastic, moved aside, and to your point, that was more hurtful than the predictable opposition of folks like Schwarzenegger.
So fast forward from 2004, 2008, the state Supreme Court says gay marriage is okay. You hold a press conference. And rather famously said, whether you like it or not, gay marriage is coming.
Best moment.
Would you have done that differently?
Yeah, of course. It was interesting. It wasn't my press conference. It was the city attorneys, and frankly, I didn't anticipate winning. I was stunned And I sat there with this energy and intensity and what this meant to so many people. And they said, the city attorney's having a press conference, come on downstairs. And I got caught up in that moment. And I also was talking about the history of the rights movement, where whether you like it or not, over the objections of the majority, this country has always fought for the rights of minorities, whether we like it or not. So the rift went there and obviously was used quite effectively in that campaign.
Living through history.
It's a remarkable history in this country. We ultimately, as Dr. King said, that arc of history bends towards justice. We eventually get it right. And in this respect, the words were wrong. They were inartful, whether you like it or not. But, the majority is not always necessarily there. But I think now the majority of Americans are on same-sex marriage. I think it will make it a lot easier.
Lieutenant Governor Gavin Newsom, thanks so much.
Thanks for having me.
The court of public opinion is shifting in favor of marriage equality. A recent field poll found that 61% of Californians now say they support same-sex marriage. 32% oppose it. And the political climate is also changing, with politicians on both sides of the aisle now speaking out in support of gay marriage. Earlier today, I spoke with attorney Andrew Pugno from Washington, D.C. He's part of the legal team defending Prop 8. Andy Pugno, welcome.
Good evening.
It's been 9 years since Gavin Newsom first issued marriage licenses at City Hall. A lot has changed. The polls show a shift toward support for gay marriage. We've seen some prominent Republicans come out in support of it. How does that change the job that you and your legal team need to do next week before the Supreme Court?
Well, really, it doesn't and shouldn't affect what is a legal case where we're looking at an interpretation of the U.S. Constitution. And things like public opinion polls and the political pressure that can be brought to bear really are just, that's just not for a legal case like this.
So do you think the justices are more or less immune to that?
I think the justices are accustomed to avoiding being sucked into a political debate, and I think they'll be mindful of their role, their limited role as judges, to interpret existing law, not to make new law.
Well, tell me, what do you feel is the essential thing you and your team have to make sure that the justices hear on Tuesday?
One of the most important things is that the justices realize that this is an issue not just of marriage, but also of states' rights and federalism. And it would really be unfortunate to have same-sex marriage imposed, marriage redefined for all 50 states, by the intervention of the federal courts, thus ending a debate that continues to go on today throughout the country. And I think that that's probably the most important thing the court should be thinking about.
The essential element of your argument in the legal briefs is that marriage is a special right and that it should be reserved for opposite-sex couples to create that link between their biological offspring. And I'm wondering, what's your point about why extending that same right to gay and lesbian couples who have kids, why would that weaken the institution of marriage if you just allowed everyone to have access to it?
That's just simply the wrong legal question. Not what harm would it cause, but whether or not it would serve the purpose of marriage. The purpose of marriage is to bind men and women together to increase the likelihood that children born of opposite-sex couples will, as often as possible, be raised by the mother and father that brought them into this world. And redefining marriage to include same-sex couples doesn't promote that purpose.
But how would it undermine it? Or is that, you think that's not relevant?
It would undermine it because it would sever the link between marriage, between man and a woman, and the rearing of children by the mothers and fathers that bring them into this world. And by severing that link, it would undermine this purpose of marriage and really turn it into an adult-focused institution to the detriment of children.
But this week, the American Academy of Pediatrics came out and said that gay marriage would be the best thing for children in being raised by two moms or two dads. So what would you say to that?
I would point out that even the experts of the plaintiffs in this case, in the trial that was held, they all had to admit that, first of all, redefining marriage would work a substantial change on the institution, and second of all, that really no one is capable of predicting with any certainty how redefining marriage would affect society in general.
And so you think the stakes on Tuesday are what?
I think the stakes are very high because you're talking about not just the institution of marriage, but also kind of a larger question of, are we going to have a judiciary that creates new law because of essentially substituting their judgment for the judgment of the people who, through the democratic process, should be making these important policy decisions.
If Prop 8 is struck down, as the lower courts have done, do you feel that's the end of the road then for your group in California, or is there some other avenue you would pursue?
If the Supreme Court decides that there is a hidden, invisible right to same-sex marriage in the Constitution, that would spell the end for Proposition 8 in California.
All right, Andrew Pugno with ProtectMarriage.com. Andy, thanks so much.
No trouble. Thank you.
And joining me now to put it all in context and discuss the legal issues before the court are UC Davis law professor Vic Amar and Jane Schachter from Stanford Law School. Good to have you both with us. Well, it's finally here, almost, these oral arguments. And Jane, let me begin with you. Both of these cases, DOMA and Prop 8, have to do with same-sex marriage, but they're different. Explain the differences.
Yes, they are different. The Defense of Marriage Act, called DOMA, is a federal statute. It was enacted in 1996. Proposition 8 is a California measure enacted in 2008. They're related in the sense that both of them are part of what we might think of as a backlash to early efforts to legalize same-sex marriage. And those go back even further than Mayor Newsom to 1993, when Hawaii looked like it was going to legalize same-sex marriage. Only a few years after Hawaii looked like it was going to do that, Congress got into the act and passed DOMA. And the section of DOMA that's being argued before the Supreme Court next week basically says that the federal government will not, may not recognize in any of its many programs a same-sex marriage that is recognized by the state. And that means, in terms of estate tax, veterans benefits, some 1,000 programs. Even if a couple is legally married in the eyes of its state, it's not married in the eyes of the federal government, and that's a new policy for the federal government, not to follow the states. Prop 8 only speaks to California and bans same-sex marriage in California.
Vic Amar, they are different, but they also intersect, and legally they intersect. We're going to learn a lot about perhaps what the justices feel about DOMA on Tuesday when they ask questions about Prop 8. So what are the legal entanglements here?
There are some commonalities. And as Jane pointed out, the statutes are different in that the Supreme Court could strike one down without affecting the other. There are ways to do that. But both at the procedural level and then at the substantive level, there are commonalities. Procedurally, both cases require the court to ask and answer, how do we deal with a case where the elected officials who ordinarily defend a statute, the president, the attorney general of the United States, the governor, the attorney general of a state, decline to defend? Because in both of these statutes, the elected executive officials have declined to defend. So that's a common question in both. And then on the merits, at base, the cases ask a very fundamental question of equal protection under the 14th Amendment. How skeptical should the courts be about laws that discriminate on the basis of sexual orientation?
But to be clear, they could strike down DOMA and it wouldn't allow anybody to get married.
That's right.
They could. But if they strike DOMA down on certain grounds, if, for example, they say that DOMA violates basic rights of equality, that leaves a lot of the states that have banned same-sex marriage kind of dangling.
Yeah. There's also this question, as you said, of standing, whether and the Supreme Court in both cases has asked both sides to argue why they even have the right to be there. How big a deal is that? Is that kind of a sleeper issue?
Well, I think it is a big issue, and one of the cues we have of that is the Supreme Court specifically asked for briefing on that question and is allowing time for separate oral argument on that question in these cases. In both cases. I think the issue of standing in relation to Prop 8 is a really interesting one, because as Vic said, the Attorney General and the Governor from the get-go have not defended Prop 8. And the question is whether the proponents of Prop 8, represented by Mr. Pugno, who we heard from earlier, have the right to do that. Now, essentially, the ballot proponents are private citizens. They're not government officials. They're not the people elected to make litigation decisions. So you have a situation where you have private parties who might be able to make litigation decisions and take positions for the state and have no accountability for that, nor any delegation of authority to them. But on the other hand, If those proponents don't have standing, then elected officials have an easy end run around direct democracy. So you have these two competing,
and of course,
clashing
the initiative
policies.
device was initially designed to be a check on elected officials who might not be responsive to the people.
But you can write into a proposition that if no one defends it, we can. They didn't do that.
They didn't do that, and I've written for a few years that it would be a different case had the people of California, the same night that they passed Prop 8, also formally deputized these folks. Because when you write that into a measure that if this passes and the Attorney General doesn't defend, then these folks will have the standing to defend, you can also answer some of these difficult questions about accountability. For how many years can they defend? How do they interact with the state, et cetera, et cetera?
Right, and there have been initiatives in California where that's specifically been written in. So the absence of that language may be significant in this case.
In the districting initiative passed in 2008 that provided for a different
political
way of,
redistricting.
Yeah, there was a provision that dealt with the possibility of
they probably knew the government wouldn't defend that because the politicians didn't like it. A lot of people are comparing this issue of same-sex marriage with interracial marriage.
Yeah.
And of course, in California, the ban on interracial marriage was struck down, I think, in 1947. It took the Supreme Court, the U.S. Supreme Court, 20 more years, 1967. Like, is that a good analogy, do you think? What are the strengths and weaknesses of thinking of it that way?
One of the interesting pieces of that question is that when the California Supreme Court acted in 1948, there was basically no public reaction at all, no backlash. It's just a very different time historically. But I think one of the things we can say is a lot of the same law, a lot of the same precedents are in play. But one of the things that's different is whenever race is involved in a constitutional challenge, the court looks at that policy of drawing a line based on race with maximal skepticism and the highest level of scrutiny. And one of the things we're going to find out in this case is whether the Supreme Court thinks any kind of heightened skepticism is in order when sexual orientation is the basis.
And I think race is the easy paradigm case because the 13th, 14th, and 15th Amendments, and the 14th Amendment is the one that houses this equal protection idea, they were about race if they were about anything.
These are after the Civil War.
Right, so there's the historical case for that. But and I do think there are parallels between these kinds of discrimination, but here's another difference, and that is in 1967 when the Supreme Court in Loving versus Virginia invalidated the ban on interracial marriage, it pointed out that at that time only 16 states retained such a ban, and that in the previous decade plus, 14 states had moved away from those bans. Right now, we still have a situation where 40-ish states prohibit same-sex marriage. That may change in 4 or 5 years, but it's a little bit different kind of a backdrop in terms of which states are the outliers and which ones are in the mainstream.
Although, go ahead. Yeah.
I was going to say, one of the things that's interesting is how fast public opinion is moving.
Exactly, yeah.
So in the case of interracial marriage, actually in 1967, there were polls that show there was lower levels of support for interracial marriage when the Supreme Court acted than there are today.
Right now, yeah.
But there's still the fact that there's many states, and I think one of the reasons is there's a big regional divide.
Yeah. More so here.
On the East Coast and West Coast, there's much more sympathy for same-sex marriage than in the South and in parts of the middle of the country.
And that gets to the question of how if they strike down Prop 8. I mean, they could, of course, uphold it, but if they have several options if they decide to strike it down, and more or less it's the California only option, or
they can strike it down because there's certain features of Prop 8 that are problematic that aren't true of other states that ban same-sex marriage.
Right. Or there's also, I think, there's another way they could do it, which the Obama administration was recommending that would affect maybe 7 or 8 states, like other states like New Jersey and Nevada. Yeah. And then there's the 50-state solution where they just say everyone has a fundamental right to marriage, whether they're gay or straight.
The Ninth Circuit, when it struck down Prop 8, tried to craft an opinion that was particular to Prop 8 so as to keep the Supreme Court at bay.
Yeah.
And the fact that at least 4 justices thought they should still take the case suggests that maybe that wasn't an entirely successful effort. Yeah. But I don't think the court is really anxious to wade into this thicket. So something that enables it to act incrementally or perhaps duck the issue altogether, as Jane said, by pushing it off, by finding the sponsors don't have standing, may be attractive to at least some of the justices.
The interesting thing here for me is that when you pair DOMA with that's the federal policy, with the very California-specific ruling about Prop 8 that the appellate court wrote, really good just for California, that ruling. If the Supreme Court were to strike down DOMA and were to strike down Prop 8 on that basis, that would be an extremely incremental step relative to the 50-state solution.
Assuming they don't strike down DOMA, on some broad grounds.
Right, exactly. So it really depends how they do it. But nobody, as you pointed out, Scott, nobody will newly be able to get married in terms of same-sex couples if DOMA falls. It just goes to the federal government recognizing those marriages. So, you know, Justice Kennedy, who has written the 2 major gay rights opinions, may be interested in something relatively incremental. That might mean one case and not the other. If that's true, I think it would be DOMA before Prop 8.
And there's an assumption, of course, that he's the key vote. But could there be other votes from other justices in play here for one reason or another?
When I listen to the argument tapes, I'm going to be wanting to see what Justices Kagan and Chief Justice Roberts and Justice Breyer, who could also be incrementalist bellwethers, and I'm not sure that they're ready to take this step. They might be.
The step of going beyond California,
or even invalidating
California.
I mean, let's not forget, invalidating a law in the biggest and most important state in the country on grounds that you try to limit to California, but that have a way of creeping out and affecting other states is not a trivial thing.
Well, you know, we live in this bubble here, a liberal bubble in the Bay Area. There's a lot of opposition to Prop 8 here, but how heavy a lift is it? How big a deal? And it kind of goes to what you just said, Vic. I mean, we shouldn't assume that they're going to strike Prop 8 down.
No, we certainly shouldn't assume that. I mean, it would be the first federal ruling in favor of same-sex marriage if they were to do it. And the California specific quality, I think, is of an opinion that might be written is undercut by the fact that California is often a bellwether for other states.
Yeah.
And Scott, you mentioned these national opinion polls, but as Jane said, it's very regionalized. So, you know, it's not as if, you know, there's going to be same-sex marriage in all 50 states anytime soon, but we still might have significant change in the next 3 or 4 or 5 years, such that the court might want to wait. And if it has means open to it to kind of push this issue off for a few years, the backdrop against which it decides these questions may be a little bit different 4 or 5 years from now.
Short on time, but what are you going to be listening for?
I'm going to be listening for what Justice Kennedy has to say, and I'm going to be listening for what they think about the rapid change in public opinion and the fact that the political process is engaging with this issue.
They'll be talking about that?
Well, I think that might be a reason why the court stays out of it. On the other hand, if the court isn't talking about that, it still might be affected by it in the sense that they may view the issue differently today than they would have 10 years ago.
And we will get the audio tapes about 3 hours after that. It's kind of unusual. They realize, obviously, this is a big deal, and people are lining up already.
Sure.
On Thursday, they were lining up to get into the court. So we look forward to that, and obviously much more to talk about. Jane Schachter from Stanford, Vic Amar, UC Davis. Thanks so much for coming in. We'll be following it, I'm sure. Thanks to everyone for joining me tonight. I'll be covering the U.S. Supreme Court hearings from Washington next week. You can hear my reports on KQED Radio and find the rest of our coverage by going to kqed.org/Prop8. And you can follow me on Twitter @ScottSchaefer. That's all for tonight. Thanks for watching. Good night.